Supporters say it's a bill designed to protect the reputation of the wrongfully accused. Opponents say it would effectively muzzle the media's ability to report on everything from arrests to public meetings. Here to discuss a proposed change to Florida's defamation law is Jennifer Mansfield, First Amendment and media law attorney here in Jacksonville. Good morning, Jennifer.
Good morning.
Nice to have you. This bill would require media outlets to remove false, defamatory, or outdated reports from their websites. Sounds like common sense. What is so wrong with that proposal?
Well, thank you for letting me address that. Traditionally, our defamation law actually came from England, and so if during high school classes, if you saw that the Florida Constitution says that English law prior to July 4th, 1776, is the law of Florida, you might have thought that that was just an arcane reference to the Revolution, but it's actually substantive law that Florida adopted when the United States was created. And traditionally, before the revolution and up until now, there is no obligation of a defamation defendant to take down material. And if you think about it as a practical matter, in the days of when it was only newspapers and books, to search every library in the country to cut out an article from every edition of a newspaper that might have been found defamatory after a jury trial is just impractical.
So it would be impractical in the sense of having to go and physically remove, you know, old information, outdated information. But in the modern era, even if it were impractical, what is wrong with the idea of removing information that is false, defamatory, or outdated?
Well, the incident that's prompting this legislation it is is a report about or reports about a criminal prosecution that someone alleged against a prominent individual, and he claims ruined his life. And eventually, the criminal charges, were dropped. Um, but he doesn't want the images to be retained on the internet of the reporting about the initial appearance of the criminal court proceedings. And I mean, as a lawyer who represents media, we get those requests all the time because an unfortunate accusation was made, charges were dropped. They don't want their reputation blemished because it comes up in a Google search. Um, but the reporting about the criminal proceeding was accurate. And if you were to have someone who was, for example, potentially abusing the criminal justice system by making false accusations regularly, wouldn't we want to know about that? And if every time charges were dropped, it was erased from the collective memory, there'd be no way to find that pattern.
So this, as you say, it was inspired by a case. It was actually out of South Florida. There was a very prominent CEO, and he was accused of molesting a 6-year-old girl. Very inflammatory accusation. He was accused by the girl's family. In that case, there actually weren't charges filed. So there were not. It was not that they were filed and then dropped. He was null prost. Basically, the state attorney determined there wasn't a buildable case and didn't file charges. He asked the TV stations that reported on it, saying because he couldn't get a job, he lost his job. He asked the TV stations to remove the story, and 2 of them did,
Hmm.
and 1 of them would not. What would be the justification to remove it in this case if 2 of the 3 did?
Well, in this day and age, people will take down articles from the internet to avoid litigation because litigation's expensive.
Mm.
And um, if it's a prominent person who has the wallet to afford litigation, then that could be why. There are a lot of mainstream organizations that will have their own code of ethics internally to their organizations that might also provide for it to be taken down. in certain circumstances.
So this man's attorney is a name. His name is Barry Richard. He works with the firm of Greenberg Traurig, who actually represented the George Bush team in 2000. So a very prominent law firm. He spoke at a hearing last week before the Senate Judiciary Committee. Let's hear what he had to say.
The media receives a privilege none of the rest of us have. The privilege says that if they publish a story accurately about an event with no reason to believe that it's false, they get this privilege, which means even if it turns out it was false, they're not liable for it. But it can stay up forever, even when they've learned it is false. How does that make sense? If they weren't entitled to the privilege when they first posted it, if they knew it was false, why should they be able to keep it up forever, knowing that it's false? It just makes no sense, and it can destroy people's lives.
So explain to us, explain to people who are listening, if I'm not allowed to post something knowing that it's false and receive any protection under the law, why should I be allowed as a reporter to leave up something that I know is false and still enjoy that protection under the law?
I would like to correct the first statement he made,
Okay.
in that it's not a privilege that only the media enjoys. Anyone who speaks about a public figure uh, has the ability to make an honest mistake. And then that's the New York Times versus Sullivan decision that people probably heard about. And so for any public official or public figure who's so prominent, um, the standard is that they have to know that that what they wrote was false, or had a really good reason to believe it was false at the time that they published it. Um, and if that's the case, then they can't be liable for defamation. And it's, as the Supreme Court wrote in that case, it's to give the First Amendment breathing room because people make honest mistakes. Now, he's talking about reporting of allegations against him, and the media, anyone, the media doesn't have a special privilege about defamation law. They tend to be the focus of defamation law because they're often used as a surrogate for the public to attend court proceedings and to go through public documents and report to the public who doesn't have the time to go do that research themselves, right? But everyone enjoys that privilege. And the again, the the reporting was not inaccurate, right? The accusation had been made. And his complaint is that the underlying accusation was determined to be false, right? Well, charges were never filed. That doesn't necessarily mean they were determined to be false. But the underlying report of the fact that the investigation was made, that the accusation had been made, were all true. And in today's internet age, it's easier now than ever to follow up, to do follow-up research, to say, oh, whatever happened to that accusation? Whatever happened to that criminal prosecution or civil court case, right? So it's not the report by the media that damaged his reputation. It was the accusation that damaged his reputation.
If you're just joining us, we're talking about a proposal to change reporting freedoms in Florida. It is being discussed by the Florida legislature, and we are talking about it with a local First Amendment lawyer. If you'd like to join the conversation or if you have questions or comments, give us a call at 904-549-2937. You can also email us, firstcoastconnect@wjct.org, or you can reach out on social media. We've got a call from Kate in the Rail Yard District. Good morning, Kate. Go ahead.
Good morning. It just seems so easy in the age of internet when they file a story like this to put some sort of reminder on them to go back and then say what happened. Put at the top of the article, the original article, these people were not found worthy of being charged. Explain the situation so that at least people can't use this against them falsely.
It's a good comment, Kate, and I know that that's something that came up at this hearing last week. Jennifer, one of the representatives of the Florida Press Association, saying that the better requirement is to require publishers to update a story or to publish a correction if that is appropriate. Why is
Mhm.
that not just sort of a universal rule?
Well, the First Amendment not only protects what you say, but it also prohibits the government from compelling you to say things. And so, a requirement to provide an update would be compelled speech and likely to be held unconstitutional for that reason.
Wouldn't it just be good policy or practice, though, for a news outlet to say, "We wanna make sure that the stories that we have published are accurate"?
It probably would, and I think most of the um, established media entities do that. You'll often see on websites at the end it'll have hyperlinks to follow up stories. Um, but I think there's also a practical concern of staffing, right? The news cycle is fast. You write a story, you publish a story, you move on to the next one. You might not hear about the follow up. Um, the the problem One of the problems with the proposed legislation is that it's being inserted into a provision in Florida law that requires notice to be filed against a media entity before you can file a defamation lawsuit. And the purpose of that was to try to avoid litigation. And so if you provide proof that something was wrong in an article, and if you publish a retraction, um, then they can still sue for defamation to recoup actual damages, but they cannot have punitive damages. And what this statute or proposed statute change would do is take away that protection, take away the the incentive to publish a retraction, um, and avoid punitive damages that way, because all it says is if you're provided notice that it's false, and you don't permanently remove it from your website, then you can be sued for punitive damages, and it would also basically remove any statute of limitations. And a statute of limitations is a concept in the law that you have to sue to redress your damages within a certain period of time because memories fade, documents, disappear over time, and they want things resolved when you can still have the evidence for it.
This bill would actually change the statute of limitations from 2 years from the time that something was published to 2 years from the time that someone was notified, a media outlet was notified that something was incorrect, which would greatly extend that period of, um, susceptibility to being sued.
Well, yeah, I mean it says that the it would be a republication. And right now Florida has what's called a single publication rule. The first time it's published, if you don't touch it, it it's not republished every time someone does a Google search and reads it,
Right.
right? It was there to be read, just like a book in the library is there to be read and someone picks it up and reads it, right? So 10 years from now, if someone notices the article and sends a notice to the publisher that something in it was false, is there a statute of limitation for that?
Yeah. We've got a call from John in St. Augustine. Good morning, John. Go ahead.
Yes, the government shouldn't be telling media outlets what to publish as long as what they're publishing is accurate. So, for example, if somebody's accused of a crime and the fact is that they were accused of a crime, and the charges are dropped, but they were still accused of a crime, that's an accurate thing. And the government shouldn't be controlling what the media says. And if the media is, the media should do an update or a correction. But if they're not, then the control on that is the marketplace. People are going to lose trust in that particular media outlet. They're going to ridicule it. They're going to stop paying attention. With all the various social media now that we're no longer being censored, they can be called out and shown that their articles are not being updated or that they're smearing people. There can be bad behavior by the media, but that doesn't mean that the government should come and tell them what they have to say or not say. And that's about all I got to say.
Thanks, John. I mean, one question that pops up is, if you are required to remove an article, or if you feel that you could be sued for reporting on something that hasn't been carried to the final term in terms of, say, a criminal charge, or if somebody's acquitted. You think about cases where people were acquitted at their first trial, Casey Anthony, O.J. Simpson, R. Kelly. Those are all very prominent cases that we would expect the media to be covering. And yet, because they were acquitted, and presumably someone could make the case that those charges were wrong or incorrect, that would presumably fall under this new guidance.
I think you're correct on that. And the caller, John, accurately described what's called the fair report privilege. And so anyone, not just the media, although it's the media who usually relies on it, right? Because that's their job to report things. But the fair report privilege is to fairly and accurately report on a governmental proceeding, a court case, a document. So if the sheriff's office releases an arrest report, right, and someone says that something in the arrest report was inaccurate, that's not defamation by the media, because the media is just reporting what the sheriff's office is doing and the reasons in the report for what the sheriff was doing.
I'm curious, this is a question my producer had, but I mean, how does this apply to something like the sheriff's office? If they put out on social media, their website, a mugshot, an arrest, they're putting out a notification, that person is later acquitted or the charges are dropped. Would this also apply to them?
Potentially, yes. And there's actually been a lot of litigation about mugshots for that very reason, that they say that it criminalizes them in the eyes of the public. They're usually unflattering, and a lot of people don't want mugshots released for that reason. The opposite end of that is you have to be able to report on who our police officials are arresting, right? That seems a basic function of society monitoring its government,
Hmm.
right? And so you have these countervailing um, principles that are in conflict with each other. And ultimately, if someone reads one article about someone being investigated or arrested, shame on them if they don't do further research and just assume they're guilty, because that's the opposite of what our justice system provides.
There is sometimes some confusion about media, and I want to listen to a comment that was also made at this uh, hearing recently. Democratic Senator Rosalind Osgood was talking about. She voted in favor of this. Let's listen to what she had to say.
If you're a reporter or just a person having a conversation, you should have enough respect about yourself and for your neighbor as well, that you try to investigate, that you don't just hear something. It's like gossiping on the website and it just goes unchecked. So I'm going to be a yes on this bill, and I hope we get more bills to begin to just let people know they can't just put stuff on websites because they say that they have a freedom of speech.
I want to ask you about that because there are comment sections. There are people who will troll you on social media. There's all kinds of reposting forums for news articles that sometimes people conflate with the actual initial report. And it sounds like perhaps the senator is sort of talking in some ways about both of those things.
Yes, you traditionally under defamation law that we inherited from England and is still the law today, the republisher of false information can be liable for defamation. And that that is the law. It's not going to change. And so journalists, when they're preparing their news stories, have to verify facts, because if it turns out that what they're reporting is false, they can be liable for defamation. And I think most of us would agree they should be liable for defamation, right? But if you're reporting on a criminal proceeding, there's no obligation of anyone to go behind and determine if that person is truly guilty before reporting on that criminal proceeding. And likewise for a civil litigation, whether the plaintiff or the defendant is the rightful party, right? Because otherwise you couldn't report on any court proceedings without potential liability for defamation about what you're reporting.
I want to take a call from Dylan in Avondale. Dylan, go ahead.
Hi, thanks. I think what's missing here is the times have changed and the commons are no longer an individual piece of paper like a newspaper that I receive and then throw away. They're infinite. So many decisions are based, I do hiring and firing all the time based on HR departments, and we have to historically look at individuals. And this seems to me to be some kind of anachronistic argument that's not taking into account that people's lives can be ruined by incorrect information. I certainly respect the media. I think it's so important. But I find this argument to be almost technical, without the kind of compassion for individuals who have been, shown to be innocent. I'd like the speaker to talk about how she would feel if this kind of thing happened to her, and it would then impact her life and her future and her family's future. That's my question.
Certainly there is always the argument, Jen, that times have changed, right? And this is a different era because the internet is forever, because everybody has access. It's not like I'm going down and looking at the microfilm from 10 years ago. I'm looking at a story that was posted 10 years ago, and I can do it from my keyboard, and it does affect my job prospects. So what, to his point, what would you say about that? I mean, do we need to come to a modern interpretation of what is appropriate in terms of just acknowledging the life of the internet?
Well, just like there was an impracticality of going to a library to cut out the articles from a newspaper or to take down every book, one, this statute does not require a final judgment in a court of law that the article was defamatory, right? The media loses their fair report privilege defense, essentially, if they don't take it down by mere notice. So anyone with an agenda who hires an attorney to send a notice that says it's false triggers this statute, right? And I think that the callers are saying that if it's been found to be not true, and that's not at the notice period.
So it's one thing if some case has gone to its final conclusion, somebody has been exonerated, you receive a notice and you're asked to take it down. But you're saying that just if I object to this story, maybe if I don't even have an attorney and I send a notice to a local news outlet and I say this story's wrong, that counts as notice for you to take it down as a news outlet. That's what this law would basically mandate. You'd take it down or you would be subject to defamation lawsuits.
Yes. More importantly, you don't have what the notice provision does now is says if you correct it, if you publish a retraction in as prominent a location as the original article, then the person who is defamed cannot seek punitive damages, right? And punitive damages are just to punish people for purposefully doing bad things, right? And that makes sense in that context. But this statute would take away that. It would allow people to sue for punitive damages. So this type of legislation will increase litigation, and frankly, it'll increase politically motivated litigation. People with an agenda who want to drive what is the quote unquote truth. And so if there's any kind of what Sam Morley said, if there's any kind of update that needs to be made to the story, It needs to be after the judicial proceedings.
And it's worth noting that this law would apply not just in Florida, but for anything that's published that affects somebody that lives here in Florida could file suits. So there's this concern about
And
litigation tourism.
I
I
would
just want to take a call from Eric. Eric, go ahead. Eric, are you there?
Hi,
Yeah.
my concern is about. Hi, can you hear me?
Yep, go
My
ahead.
concern is about lying politicians. There's an asymmetry between what is demanded of the press and what's demanded of a politician who knowingly lies. If a politician were forced to retract what is known to be a lie, it might be a fair law. But without that, the politician as an individual can claim protection of the First Amendment and claim he doesn't know it and claim that he has the freedom of speech. And that's the problem. When you deprive the press of that freedom, but you don't deprive the individuals of that freedom, you have a radical asymmetry that's very dangerous.
Thanks, Eric. Jen, we're going to have to leave it there. Just final thoughts for people to consider.
I think the argument about the internet being a new age and making things different is true in the sense that people don't have the privacy, the ability to hide from the media as much because everyone has access at their fingertips. But on the other hand, they also have access to all the follow-up information. So like I said at the front end, the ability to research what happened in the end is easier now today than ever before.
Yeah. Well, Jennifer Mansfield, thank you so much for being here. Really important conversation.
My pleasure.